All right, so I will call this on the record, Nancy. Go right ahead, so we don't have any hidden.
Okay, give me just a second here.
All right.
I pulled up another case. I'm good.
All right, we are on the record now for people of the state of Michigan versus Jacob Wright. File number is 26-14196FH. Appearance, please.
Nate Carnes on behalf of the people.
Attorney James Scozzari on behalf of Jacob Wright.
Thank you, sir. And Jacob Wright is here in the courtroom. We are here today for a pre-trial conference. This is the first time, Mr. Wright, that the court takes a look at the case on the record for in chambers and the attorneys tell me what's going on. Now, Mr. Gazzari is probably handling this. Mr. Gazzari, are you appointed or retained?
Your Honor, I guess that's kind of a funny question. I'm from the Michigan Special Assignment Unit. I believe the prosecutor in the case, or excuse me, the assigned counsel on the case may have been conflicted out for whatever reason. So I guess you could technically say that I'm appointed.
Okay, that's the longest explanation I've ever had to that question, but that's okay. All right, so Mr. Gazzari, because you're new, I don't think I've ever seen you here before. I have just started recently using a form for pretrial conferences, and I know that when this case got its scheduling order from me, I didn't have all the language in it that I've just recently changed. So generally, for pretrial conferences, I now just use a form and you guys fill it out, and it asks a series of questions that I'm now going to ask right now. Here we go. Mr. Gazzari, have you gotten a copy of the felony information and have you shared it with your client?
I have, Your Honor.
And have you received the discovery from the prosecutor's office, or is there anything that's taking time?
I've received most discovery, Your Honor. The only thing I would note is that I am missing the official CCH that generally gets shared with me. I understand that the Wexford County Prosecutor's Office position is that they don't share that. So I do have an informal CCH from my client. The only thing I would note is it does make it a little difficult to accurately score my client's guidelines. I mean, I can come up with a roundabout estimate, but I guess that would be the only thing I would note for the record, Your Honor.
Yes, Mr. Kearns.
Your Honor, while I can't share lien, I can type out a list of the convictions and I'll do that. This is the first time hearing about it, but I'm happy to do that.
All right, that's good. And you can also give each other a call and you can go through the detail. But yes, sir, Mr. Gazzari.
Thank you, Your Honor. Yeah, just to be clear, and I am not blaming anybody here. I did have a back and forth with somebody in the Wexford County Prosecutor's Office. Their name is escaping me. And we did discuss this issue, so it's not for lack of trying. The only thing that I'm concerned with is that I have this informal list. I know sometimes when we get, the lien, there are things that don't show up for us because obviously I don't have access to his lien information. And I understand that the prosecutor's office can't share that with me. I get that. So I guess, that's the only thing I would note for the record.
No problem. All right, thank you. Next question here is, have you been able to meet and talk with Mr. Wright?
I have, Your Honor. We've discussed this case a few times. I did communicate the initial offer that the Wexford County made prior to the probable cause conference. I did confer with my client yesterday. I did email him the pretrial form and the communicated offer. My client is aware of it.
Mr. Wright, is that correct?
Yes, sir.
All right. If there are any other issues or discovery issues, please make sure you let the court know. Was there a preliminary examination held, Mr. Carnes?
No, Your Honor, it was waived.
All right, good. So we don't have any transcript issues. That's another thing that I look here, is just to make sure we're getting everything that you all need. All right, thank you. Now, the next thing I'll highlight here for both Mr. Wright and Mr. Gazzari, and this should be in the scheduling conference order, because this is generally a policy that I've done now for a couple of years. When we get to a final pretrial conference, which is on a Friday, and typically on a Friday, and the trial is set out about 10 days thereafter. On a final pretrial conference day, there might be 4, 5, 6 cases set for that date, and they're all set for the same trial date. Any case that doesn't settle on the final pretrial conference date will remain on the docket for the trial date. Typically, the oldest one will be the one, if it's still standing a couple of days prior to the trial, typically the Friday prior to, and all my trials are on Tuesdays and Wednesdays, then the oldest one will go. The only time that doesn't happen is if there's another one that's not as old, but the guy's in jail or the person's in jail and we have a speedy trial clock issue that forces me to take that case first. But here's the key point. On final pretrial conference date, that is the last date. If your case is the one that goes to trial and 10 days later, that is the last day I will accept the pretrial agreement. Otherwise, if we have a trial and we show up, the defendant can plead guilty as charged. That's it. The reason why I have this policy, Mr. Wright, isn't to punish a defendant, isn't to force the defendant to do anything. For instance, you might show up on a Friday and say, hey, let's wait and not take it. First of all, I don't know if you need to take, I don't even know what the charges are right now. So you know I don't have any opinion. You don't know if you don't want to leave that date thinking, oh, I bet if I wait to the very last second, it'll get better. Well, the problem is I have to have 90 people show up for potential jury selection. They've all got to take time off of work, get somebody to pick up the kids, take the dog to the vet, take grandma or grandpa to a medical appointment. They have to do all that other stuff. And we got to get witnesses here. And they've all got to stop their lives and come here too. So before all those wheels start moving, I have this policy to make these two brilliant attorneys do all of their negotiating skills. So you know, Mr. Kazari and Mr. Carnes have fought out in the parking lot, fisticuff. Right? I don't know which one might win. I never get to watch them fight, but I should. But anyways, you know that that's it. It's not going to get any better. And that's for you as well as it is for all the people that I have to bring in. Because you know, Mr. Carnes knows Judge Elmore won't let him enter a plea or change it. Therefore, I know Mr. Carnes has made the best offer. Again, I don't know even what you charge with, so I don't know what the offers are. I don't know what they should be today. But anyways, I just want everybody to know that's how we handle final pretrial conferences here. All right. Anything that you think I need to be aware of, Mr. Kazari?
I have nothing at this time, Your Honor.
Thank you. How about you, Mr. Carnes?
No, Your Honor, thank you.
Mr. Wright, without making any statements, of course, do you have any questions for me about what's going on, what I've done today, what we talked about?
No, Your Honor.
All right. Thank you. We're adjourned.
Thank you.
Thank you, sir. Maybe somebody could take that back and have him sign a copy. So you want 2 copies. One will go back to Mr. Nelson. He'll take it with him. The other one, he's going to put his initials on. Well, that's it right there. You have it. Officer, could you just take one and have him, give one to him, and then he's got to put his initials. You need a pen, take a pen from Samantha. All right.
The one in there.
Yeah, yep, the gentleman we just had here. All right, now I need an attorney. Do it. Our next case here today is People of the State of Michigan versus Levi Evan Spears. This is case number 6-14201 FH. Before the court this morning is Ms. Dean Stark from the Wexford County Department for Community Corrections. The defendant, Mr. Spears, who's currently in custody, is now here at the defense table. The court also recognizes. Go ahead, tell me who you are.
Nate Carnes on behalf of the people.
Oh my gosh. All right, thank you. And now we're just waiting for Mr. Harrison. Samantha, do you do karaoke?
No, I don't.
No? Ms. Stark, do you like to do karaoke? All right, see if we get somebody to sing.
Okay.
All right.
I heard you had good reviews last time you sang
Yeah.
up there.
I know I got a couple of different songs. I like singing rap songs as if they're different. It takes 2 to make a thing go right. It takes 2 to make it out of sight. Here he comes, everybody.
I'm sorry.
Jeffrey.
Sorry, Levi. I didn't mean to make you wait either.
Jeffrey Douglas Harrison is down here in the courtroom, and we're here today for a alleged bond violation arraignment here today. Mr. Spears was here earlier this week. That was, I think, a couple days ago, or 2 days ago, on February 25th, for an alleged bond violation. He admitted to that violation had to do with failing to test. The court released the defendant or allowed him to continue or be released on his continued bond, but it ordered him to appear for to appear for testing. And the defendant did appear for testing that day after being released from the Wexford County Jail. He appeared at the Community Corrections Office and allegedly provided a sample and where he tested positive for fentanyl. But he was also found to be possessing a container allegedly with urine on his person, meaning it was either someone else's urine or fake urine. And yes, there's a such thing as fake urine. Mr. Harrison, how does your client wish to respond today?
Wishes to make an admission, Your Honor.
All right. Mr. Spears, please raise your right hand to the best you can. Do you swear or affirm the information testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
I do, Your Honor.
You may lower your hand. All right, so Mr. Spears, you do have the right to due process here today, and that is to require the prosecution to put on some evidence to demonstrate that there was a bond violation. That wouldn't be a trial. It could be considered an allegation of contempt for failing to comply with a court order, but we don't do that. We just treat this as a review of pretrial release conditions underneath what's called Michigan Code Law 6.106 paragraph H. However, I'm told today that you're going to admit to testing positive and possessing either fake urine or urine that belonged to somebody else. Is that what's going to happen?
Yes, I'd also like to just apologize to the court and to community corrections for just not being honest in the first place.
Has anybody made any threats or coercion to get you to make this admission today?
No, Your Honor.
So, Mr. Spears, is it true that when you left the jail and you came to community corrections, how long did it take you to get from the jail to community corrections?
While my ride and stuff, I ended up having to walk. And then I was cold. I ended up going to the store and then calling for a ride up to the courthouse.
What store did you go to?
I ended up at Shell.
The Shell gas station?
Yeah.
The one, is there two? Remember.
Across from.
Oh, the Shell gas
alignment
station
place?
is down by the old Cobbs Mitchell building, or the Cobbs Mitchell building or whatever it's called. I got it.
Okay.
All right, and then you got it right up to the courthouse. Okay, and when you got up there, did you take someone else's urine or a fake urine sample?
It was actually an old sample of my own.
Okay, and
I was just worried.
I got it. And
I had been using heavily before I
Okay.
got arrested,
All right.
and I was scared it would still be in my system when I got released.
Yep. All right. And it apparently it tested positive for fentanyl. Is that correct?
Yeah, I had been using heavily before I got arrested in the first place.
All right. The court finds the defendant to have violated the terms and conditions of his bond. His bond requires that he's not to use, possess, or consume any illegal or controlled substance unless provided by through a prescription from a medical provider. You didn't have a prescription for this, correct?
No, I had been struggling with addiction before jail.
I understand. All right, thank you. All right, so now that Mr. And I'll remember from Ms. Stark told us and talked about last time, has there been getting tested before that, correct? That was a yes. Left, right there, Nancy Johnson. All right. Mr. Carnes, what do you think we should do? What's your position?
Your Honor, again, this case involved the defendant stealing a vehicle while intoxicated, certainly by alcohol, possibly other controlled substances, and then crashing that vehicle. So there's a victim out of the vehicle that was totaled, and the community was put in danger, and the defendant is now testing positive and refusing to test prior medications. I think a remand is the only option here. I'd ask the court to impose that. Thank you.
Mr. Harrison, your position, sir?
Well, believe it or not, I disagree with that assessment of the situation. These are clearly acts of desperation by someone in the throes of an addictive episode. You know how addiction goes, Judge. You're sober until you're not, right? And that's exactly what happened to Levi. I wish he hadn't connived to attempt to defeat the drug test. He wishes that too. That's part of what he wanted to express to you. Ironically, when they first brought him in, they attempted to test him at the jail and he was unable to provide a sample, so they neglected to test him, released him to community corrections. He had reason to believe there would still be fentanyl in his system. The rest is what he told you. I'm happy to announce as well to the court that most of the conversation I had with Levi this morning was centered around his desire to go to rehab. And we're going to try to find him a spot as quickly as we can. Obviously, if he were released on bond, now that process could be streamlined. We wouldn't have to make a motion for release or modification of his bond to accommodate that. I don't know what else to say. I see this as he recognized he had to stop. He tried to stop. He got arrested in the interim, et cetera, et cetera. This isn't, I hesitate to use this term, this isn't new use, and he has no intention to go back to use it. It's just something that happened and the times overlap, and here we are.
All right. All right, thank you. All right, so here we go. I've already heard here from Mr. Spears about what happened. To call something an act of desperation also suggests that there must be a response. Because if someone is desperate and needs help, well, the court needs to find a way to get them that help. Also, let's not fool around here. The defendant went from the jail, which is that way, about half a mile, past the courthouse, and went to the Shell gas station. By the way, of course, I know the Shell gas station. That way, another half mile or 3/4 of a mile, and then came back here, somewhere between there, and here, that's diagonal. Triangle, I'm sorry. We should start calling it the Wexford County Courthouse Triangle, kind of like the Bermuda one. And then somewhere in all that, he got extra urine that he kept. Don't know where he kept it. I doubt he kept it there at the jail. So he must have really gone someplace to either go get old urine or someone else's, I don't know. But he didn't go straight.
There are text messages in this petition, shows he has people conspiring to get him.
Oh, yeah.
Those were attached to the original.
Yeah. Oh, that's, oh my
Better
gosh.
support network.
Yeah. Oh, I even see that on there. Nadia Yates, the person with whom he's texting, had videos or clips of our video. And that's okay. I mean, it's not a big deal. So clearly she knew what was going, and it said, I need clean pee ASAP. Gotta take Levi to courthouse. So apparently he had a ride someplace. But clearly, I'm just gonna say, I think the defendant's lying today. But he wants, it's an act of desperation. Ms. Yates, if you're watching, shame on you and helping somebody violate a court order. So, and Matthew Gray. All right. Good job, people. All right, the court revokes the defendant's bond, remands him for custody of the Wexford County Jail. You can seek to try to get him into a program, Mr. Harrison, but you're going to need to convince me that I do it. Because I will remember that he and his buddies, his friends, tried to pull one over on the court and community corrections. my likelihood of granting him a bond modification between now and the time this case is resolved, extremely low, almost zero. Thank you. We're adjourned.